immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is Nikita Bahadur and I'll be your host for today's important discussion. Understanding immigration bonds, eligibility, process, and what families should expect. When a loved one is placed in immigration detention, families often face urgent questions about whether release is possible and what steps should be taken. Immigration bonds can offer an opportunity for certain detained individuals to be released while the case moves forward. But the process can be complex and unfamiliar for many families. Understanding how bond eligibility works, what immigration judges evaluate, and how families can prepare for bond hearings can be essential during what is often a stressful and uncertain time. To help us break this down, we are honored to be joined by attorney Ibrahim Caglar, an immigration attorney who represents individuals and families in immigration proceedings, including detention and bond matters before immigration courts. Attorney Caglar, thank you for joining us today. We are thrilled to have you for this important discussion.
Thank you for having me.
Before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or another platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding immigration bond pro. Let's dive right in. Attorney Caglar, can you explain what an immigration bond is and in what situations a detained individual may be eligible for release on bond?
A great question to start with. Because a lot of families don't fully understand what a bond actually is, what an immigration bond actually is. So an immigration bond is essentially a financial guarantee to the government. It's money paid to the government to secure a detained person's release from ICE custody while their immigration case is pending. Think of it like a deposit. You're telling the government that this person will show up to every court date. If they do, the money is returned at the end of the proceedings. And if they don't, the government keeps the money. Now, who can get an immigration bond? Generally speaking, individuals who are detained under INA Section 1226A. So what this means is that they have been arrested by ICE, but are not subject to mandatory detention. So they have the right to request a bond hearing. Those are people who don't have certain criminal convictions that require the government to keep them locked up, or depending on their entry to the country. And this is very technical, but the bottom line is that if they are not subject to mandatory detention, they are eligible to ask for a bond. But Here is the reality in 2026. There has been a significant legal battle over who is even eligible to ask for a bond. Because there was BIA, Board of Immigration Appeals decision in September 2025 called Matter of Hurtado. And that decision made many people who entered the country without inspection not eligible to ask for a bond. But courts across the country have been pushing back on that, especially the federal district courts. A federal district court in California recently issued an order vacating that decision, that BIA decision, in February. But the battle is not over. So eligibility right now is a moving target, depending on where you are, and also depending on your manner of entry. So that's why this is exactly why having an immigration attorney is very critical if you are going to ask for an immigration bond.
And who has the authority to set an immigration bond? And how does the process differ between ICE custody determinations and immigration judge bond hearings?
Great question. So there are actually two separate paths here. First is an ICE custody determination. When someone is initially detained by ICE, ICE can decide on its own to release the person on bond without ever going to the court. ICE will look at whether the person is a danger to community or a flight risk, and they will set a bond amount. But this does not happen that often. Usually, the reason is when ICE detains someone, they already determine that that person needs to be detained, so there is either a flight risk or a danger to community issue here. So they're not usually releasing individuals on bond. So the second path is that bond hearing before an immigration judge. So when you can go to the immigration court and ask the judge to reconsider your detention or your loved one's detention. If ICE sets a bond, you can ask an immigration judge to lower the amount, or if ICE refuses to set a bond, you can ask the court to grant a bond. Immigration judge conducts a completely independent review, and they're not bound by what ICE decided. So the key difference between these two paths are the immigration judge hearing is more formal. There is a government attorney on the other side arguing to keep you detained or to maintain the high bond. And you have the opportunity to present evidence, make arguments, and advocate for yourself, right? And this is why that it is important to have a legal representation at bond hearings, because it's not just a conversation. You're not just asking the judge to release you. You're relying on the evidence that you have. You're presenting your arguments, and the immigration judge is making a decision based on that.
What factors do immigration judges consider when deciding whether to grant bond, and in what amount?
Great. So immigration judges look at two core questions when they're deciding an immigration bond. First, is this person a danger to community that they live in? Second, are they a flight risk? Meaning, are they likely to disappear and not show up to court? So there is a leading case here, but I'm not gonna go to the details of the case. But that case gives immigration judges a broad discretion in how they weigh the evidence. So judges commonly look at things like how long has the person lived in the United States? Do they have family here, especially U.S. citizens or lawful permanent resident family members? Do they have stable employment or a place to live? Do they have ties to their home country that might make them want to leave? Have they ever missed a court date before? That is very important because that will show that the person is a responsible person and they're not going to miss their court dates. Do they have criminal history? That is very important. So the judge is essentially asking, can I trust this person to come back to the court? That's very important. So the other, on the danger side, the other important factor that the judges look at is danger to community, right? So if the person has any criminal history, even old convictions matter, but character letters, community support letters, or evidence of rehabilitation can help counter that if you have any criminal history. One thing I always tell to my clients is that the judge has wide discretion here, but they always respond to evidence. So gather your evidence, make your arguments that you will have a chance to get the bond.
That actually brings me to my next question. How can immigrants prepare for a bond hearing, and what types of evidence are most helpful in demonstrating community ties and lack of flight risk?
Great question. Preparation is everything because a bond hearing can happen quickly, sometimes within days of being detained. So you want to move very fast. So the most powerful evidence you can bring is anything that shows roots in this country. And that means letters of support from family members, from community leaders, neighbors, co-workers. But those letters should be specific, not just like, he's a good person, please release him. No. It should be like, okay, he has worked for me for 5 years, 3 years. He has 2 US citizen children. I know them and they depend on him. So it should be specific. Proof of employment is also very important. Pay stubs, tax returns that shows that you are paying your taxes. A letter from an employer saying that they want to continue employing you. Evidence of family ties, right? Birth certificates, birth certificates of, if you have US citizen children, birth certificates of US citizen children, marriage certificates, anything that shows that this person has there are people depending on it, or evidence of relief eligibility. This is important and often overlooked. So if someone has a path to legal status, like pending petition or an application or a strong asylum claim, that shows to the court that there is a real reason to stay and fight the case. So it reduces the flight risk. And lastly, I think prior compliance. So if the person has appeared at prior court dates and they've been cooperative, that matters too.
What happens after a bond is posted, and what responsibilities does the released individual have while their case is pending?
Once the bond is paid, you'll be released. But release does not mean that the case is over, right? Here is what the person needs to understand. First, you must appear at every single immigration court hearing. This is non-negotiable because missing a court date can result in an absentia removal order. You must keep your address updated with immigration court with ICE and with USCIS if you have an application with them. Because this is so important, because if you receive a notice to your address, and if this goes to your old address, the court or can petition, the court can order to remove you based on absentia, right? So this is important too. Or if you receive an RFE, request for evidence from US citizens and USCIS, and if you don't have that RFE, you are not able to going to reply to that RFE. So you might your petition might get denied. And most of the time, if you're released on bond, you have check-in requirements with ICE. Like maybe sometimes there are periodic reportings. You have to appear in person in an ICE office with an officer. They ask you if this is your current address. They ask you what happened in your case, if you have a pending case with immigration court. Sometimes these reportings are by phone or by virtual, like video calls. You should not miss those. They're very important. They will affect your case, and avoid any legal trouble, right? Even a minor arrest. I'm not talking about conviction. Even just minor things, like you should avoid every legal trouble that you can. And most importantly, if you have a legal path to legal status here, you should work on that case, because this is your opportunity to work on your case and win your case, so you can get your bond money back and have a legal status here.
Now, if the bond is denied, what options are available for the individual?
Great question. And this is a question that I get asked a lot. Bond denials are not the end of the road, because there are several avenues. And the right one depends on the specific circumstances. First, you can file a motion for bond redetermination with the same court, or if you are transferred to another ICE facility, with the immigration court that has the jurisdiction over that facility. But there is a key here. If there has been a change in circumstances, for example, a new evidence of community ties or new relief application, something that wasn't before the judge the first time, now you can go back to the immigration court, the immigration judge, and ask for bond redetermination. If there is a change, you generally can't just re-argue the same things. You need to show something new. Second, you can appeal if your bond request denied. You can appeal to the Board of Immigration Appeals. And they can review whether an immigration judge applied the right legal standard. However, this takes more time, but it is a legitimate path, and in some cases that you can win your case. Third, and this is something more attorneys are using right now in 2026, a federal habeas corpus petition. A detained person can challenge the legality of their detention in a federal district court. This has become especially important because of the Board of Immigration Appeals decision that I mentioned earlier, matter of Hurtado. Federal judges across the country now have been granting these petitions at very high rates. and they're ordering ICE to provide bond hearings for people who were wrongly detained. So it is not. I mean, it is mostly available to detain immigrants, but it is not appropriate for every case. But it is a very powerful tool when the government has exceeded its legal authority to detain. And if so, just to summarize, if the bond is denied, it's not the end of the road. There are a couple of paths that you can ask for your release. Don't give up. Don't assume that there is nothing left to do. Talk to an attorney and decide which of these options fits your case.
Thank you for those insights, Attorney Caglar. For everyone watching, this discussion about immigration bonds is not meant to create unrealistic expectations, but to provide clarity about the process families may face when a loved one is detained. Understanding the legal standards, preparing documentation, and seeking reliable information can help families navigate these situations more confidently. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Attorney Caglar, based on your experience assisting detained individuals and their families, how does ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
It is a great question. Thank you. Simply, immigrationquestion.com helps immigrants and immigration attorneys because it bridges the gap between people who need legal help and the attorneys who can provide that help. And so for immigrants, it's a trusted place to get real answers from real licensed attorneys. And for attorneys like myself, it's a way to reach and serve and help more people, especially communities um, that are usually, they are usually, especially now with this current atmosphere in this country, that they are scared and they need help. So thank you for the English. Thank you.
Thank you, Attorney Caglar. If you're just joining us, we've been speaking to Attorney Ibrahim Caglar on understanding immigration bonds, eligibility, process, and what families should expect. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insights from a licensed immigration attorney. Please drop your questions in the chat or call us live on 516-703-3483, and we'll take as many questions as time allows. Okay, our first question. Who decides whether someone can get an immigration bond?
ICE can decide, and ICE can decide to give you a bond, set a bond, or an immigration court, immigration judge.
Yeah. Okay, our next question. I've heard that some new court decisions are making it harder to get immigration bonds. Is that true?
Unfortunately, yes, it is true. I mentioned that decision earlier today. There is a decision from Board of Immigration Appeals, and it was decided in September 2025. It's called Metro Hurtado, and it basically made a lot of people who entered the country without inspection not eligible to ask for a bond. However, the good news is a lot of courts around the country, federal courts, are issuing orders for those immigrants who are not eligible for bond. Because of that decision, they are issuing orders either to release them or either to uh, order ICE to give them an individualized bond hearing. So if that's the case, you can go to the federal district court to ask for a bond or release.
Okay, our next question. Are there people who are not allowed to get an immigration bond at all?
Yes, there are. Especially, we call them like subject to mandatory detention, meaning that if they have a criminal record, such as aggravated felony, usually they're subject to mandatory detention and they're not allowed to get a bond.
Okay, that's all the time we have for questions right now, but you can continue dropping your questions in the chat. Attorney Caglar, recent reports indicate that immigration bond approval rates in 2026 have declined compared to previous years. Changes in approval patterns can affect how families approach detention and release strategies during removal proceedings. Attorney Caglar, many immigrants are hearing that immigration bond approval rates are declining. What does this mean, and how can families better prepare if they need to request for a bond?
This is so important, and I'm glad that you asked the question. Yes, the landscape has shifting significantly, and immigration judges now have had. I mean, I don't want to go into details of how many cases they have decided this year, but they had decided a lot of bond cases, and the rates of approval are very low. And the rules that govern the immigration bond hearings are changing too because of the decisions that we mentioned earlier. However, I must say, what does that mean practically? It means the rules are different depending on the case, of course, depending manner of entry that you enter this country, but also it depends on the jurisdiction that you're detained. My advice is this: number one, get help. Not a social media advice that you should go get help from a licensed immigration attorney who is tracking those developments right now. And number two, use reliable sources. Usually, you can go to National Immigration Law Center. Like you should go get a help from a licensed person, attorney, and you should document everything, because this is what I experience most of the time when ICE detains immigrants. They are not properly detaining them, meaning that they don't have arrest warrants or they don't have the authority to detain them. They make mistakes. The reason that they make mistakes because I know that they have quotas that they have to reach, and they sometimes even detain U.S. citizens that they don't have any jurisdiction whatsoever. So document everything. Why did they detain you? Did they ask you any questions? Did they, so just document everything. I know that a lot of people are winning in courts because they document, they ask for bond, and if that's denied, they go to federal court or Board of Immigration Appeals, and they just present their evidence that they have, and they have the best chance to be released if they do this. Thank you.
Thank you to everyone who joined us for this special edition webinar. And thank you, Attorney Caglar, for sharing your knowledge and guidance.
Thank you for having me.
You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of today's discussion, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday at our next live session. Stay informed, stay prepared, and stay connected.